A warm welcome to each one of you to the first masterclass of this session. We do this masterclass with the intention that it's very important for a faculty and a student to know each other before you decide on a professional course like law. Similarly, for medicine and other professions also, it's basically the magic that takes place inside the classroom that builds institutions. So that's exactly our belief also, for which what we do is we take academic lectures. So there are some ground rules of this session. This is not an admissions lecture where we are going to entertain admission related queries. That's totally a no-no in this session because we have separate sessions for this. This is an academic session where we have a professor who is going to come. She's already there. She's online and she is going to profess. She's going to take these lectures on a topic which is very crucial to your 5-year journey in the first few years. So she's not going to go deep, but she's going to just give you a primer of the session so that you understand these things and you start reading by the time you join us. Okay, so that is the ground basis of these sessions. The second thing is, if you have questions related to the session, please put them in the chat window. We have a team who will answer to those questions. We'll pick up the questions which are relevant to the context and we'll start answering those questions. Okay, I again repeat, it's academic lecture. So what we expect from all of you is a academic question relating to the topic. So the protocol that we follow is Sunalini will take the lecture, and she will go ahead and she will deliver the lecture properly. You have to sit and listen. There is a PPT, and then depending upon this, we expect the questions. Okay, so let me introduce my colleague and associate professor of political science at the BITS Law School, Professor Dr. Sunalini Kumar. She is educated at the Cambridge University, Delhi University, and the JNU. She has previously been awarded the Nehru Chevening Cambridge Scholarship, the Oxford Cambridge Society of India Scholarship, and the Fulbright Nehru Fellowship for postdoctoral research at the Columbia University. Sunalini's research revolves around the circulation of transnational development expertise in the mid-20th century, strategy-making practices in post-colonial Asian states, the politics of land acquisition, and the rural-urban transition. Plus, she is also a great human being. That's something I want to tell you, because here inside the campus, the students and we all staff, alike like her a lot. She's got that kind of a pleasing personality where anytime I see Sunalini, she's just smiling. That's the approach, and that's what I think makes kids also go gaga over here. Okay, over to you, Sunalini. Now it's the time for you to start with the lecture.
Thank you so much, Deepu. Am I audible to everybody?
Yes, you're loud, clear, and audible.
All right. So, welcome. Good evening to all of you who have joined us on a Friday evening. I'm sure that there were other things competing for your attention, but I'm glad you're here, and I hope that we'll have a nice discussion at the end of this presentation. As my colleague Deepu has said, there is a PPT, and you already know the topic of the webinar. It is power, justice, and discrimination. You already should have a sense, given that you've applied to law school, why these topics are important in a law degree. But I hope that by the end of this webinar, there will be a few newer angles, newer aspects regarding all of these questions that you hadn't quite thought of. And I would be very happy to hear your views on, what thoughts this stirred with you, what new directions your mind went to when you saw some of this material. Before I start the PPT, I want to say that these are, these are very, very large concepts. They're very, in a way, global concepts. And so instead of discussing it theoretically, which is also perfectly valid, and we have a course in political ideologies where we do discuss some of these legal, moral, political concepts theoretically. And I believe it's also a very interesting approach. But I thought what we would do today, since you are relatively new to the subject, is to actually talk about these things through some concrete examples. And you'll see what those concrete examples are. In other words, we're going to be sticking quite close to the real world, some of it historical, some of it contemporary, and seeing how these ideas of power, justice, and discrimination actually play out in the world around us. And that's why the lecture is subtitled, How Law and Society Interact. So let's start. So we'll start with some really basic definitions, right, of law and society. These are just, from dictionaries, from the Oxford Dictionary. Law is the system of rules which a particular country or community recognizes as regulating the actions of its members and which it may enforce by the imposition of penalties. So you can already see two things here. You can see that you have you can actually see three aspects to law here. One is, of course, it's a system of rules, but it's a system of rules that is recognized within a particular context as valid. So it says within a particular country or community, right? And it says as regulating the actions of its members, but that's obvious. Rules always regulate the actions of their members. And the third aspect is it may enforce by the imposition of penalties. So law is something we accept as having the authority to not simply enforce the rule, but to also legislate and also impose penalties for non-compliance to those rules. Again, it's a commonsensical notion, right? Of course, we know that. So in that sense, just to say it's different from morality. Law is, in a way, public morality that is enshrined in a legal code and that has the power of the state, the government, and the criminal justice system behind it. And that's what imposition of penalties means, right? For example, shooting the birds is against the law. So there's something that called the law, and then there's something that is against the law, and that something is that it attracts penalties, right? There's something that is against the law attracts penalties. Society is a group of individuals involved in persistent social interaction or a large social group sharing the same spatial or social territory, typically subject to the same political authority and dominant cultural expectations, right? I won't read the rest of it. You can read what's written on the screen, but largely speaking, when I'm going to use the term society here, and it's one of the less defined terms we have in social science, which might seem ironic given that the entire discipline of social science is built around the idea of society and the social, but it can be a difficult term to define. But for the purposes of this presentation and to a large extent in the world, when we speak about law and society, we're talking about national society or what is commonly known as countries, right? We're talking about law in a domestic national context. Generally, if we mean international law, or we mean society, which is a global society outside of a country's borders, we would specify that. So when I say law and society, it would mean law and society within the borders of a country. Power. So the ability or the capacity to do something in a particular way, as in the power of speech, right? Or the capacity or ability to direct or influence the behavior of others or the course of events. So either for better or worse, if you can direct the course of events or actually influence the behavior of others. So it's both capacity, which is a personal thing, which is an individual thing, or it is the ability to actually influence others. And that influence could be negative or positive. Now, justice is quite a key concept in this lecture. And like I said, we'll be looking at some of the concrete examples in which justice plays out. But here you can just read what the Oxford English Dictionary defines it. It's got Latin roots, the word. It comes from jus, which means right or law. And sometimes, again, just like with the word society, it can be a complex word to define, right? Philosophers, for instance, will go beyond the dictionary definition and consider the nature of justice both as a moral virtue of character and a desirable quality of political society. So both something that is individual and something that applies to society at large. And here I want to say that in social science and political science, we make a distinction between social justice, which is something that applies to society at large, and criminal justice, which is something in which an individual and their crimes are supposed to be considered by a court of law, which is not to say that the criminal justice system does not deal with large-scale crimes, but overwhelmingly, to a very, very large degree, the criminal justice system recognizes legal cases between individuals. So appellants and defendants and so on are generally individuals. Of course, the law can also accommodate these definitions can also accommodate larger groups. but it still is a subset of the largest group, which is the national society. In the case of social justice, it's about redistributing. So both in the case of criminal justice and social justice, it's about balance, right? You remember all of you would have seen some, certainly some movie in which there's a courtroom scene in which there's a lady who is blindfolded, Lady Justice, and she holds these scales of justice, and they're really supposed to represent the idea that law is supposed to strike a balance, whether it is between an individual, two individuals accused who are facing each other in a trial, or even in larger society, law is supposed to achieve balance and harmony. And this is where the idea of social justice comes. But social justice, which is to do with redistribution, especially of economic arrangements, also tries to take into account a more active view of justice. So it doesn't simply seek balance by maintaining harmony and maintaining order, but by also redistributing goods and resources that exist in society. But that's not very relevant to our presentation, so we can maybe just focus on what the criminal justice system is. Just to say that justice is also a complex concept. Now, discrimination. This is something that maybe some of you have already thought about, but isn't it interesting that it has two quite different meanings, right? The first is something that, again, is quite common now, because when we think about social justice especially, which is how do we harmonize or balance our societies, which have a lot of different kinds of inequalities, different kinds of hierarchies in them, different kinds of marginalization in them. Discrimination refers to the unjust or prejudicial treatment of different categories of people, especially on the grounds of ethnicity, age, sex, or disability. It could be anything. It could be racial discrimination. It could be, as is written here, difference in abilities. So differently abled people, of course, ethnicity, age, sex. It could be religion, right? So any of these conditions. But also the recognition and understanding of the difference between one thing and another. Example, discrimination between right and wrong. Okay, so there are two very different meanings of the word discrimination, and this will become relevant as we go on. Now, as I said, instead of discussing these things in an abstract or theoretical sense, let's talk about power, justice in a concrete context. And here the example I would like us to think about is 19th century. Actually, if you're talking about slavery, it's also 18th century, but 19th century United States, which led the institution of slavery. Some of you would know about this, but just to go over the facts very quickly, the institution of slavery was formally recognized within the political and legal system of the United States. It wasn't simply that there was economic discrimination against the African American slaves, but it was also a kind of discrimination that was enshrined and recognized and validated by the legal and political system. So again, some of this is common knowledge, but just to look at what is on the screen. And I just wanted to see, just to give a visual picture, this is because the word Confederates would be used. All the states below the red line, right, were the Confederate states where the institution of slavery was defended in the American Civil War of 1861 to 1865. For 4 long years, the Confederates fought who they call the Yankees, were all north of what is this red line, which is the Mason-Dixon line. They fought over the question of slaves and whether it is legal to own another human being, for one human being to own another human being, which is exactly what slavery is, because slavery is, like I said, it's not simply a question of economic marginalization. It is a question of human dignity, where one human being is allowed legally to own another human being in the form of property. So once the Civil War ended, there was something called the Reconstruction period in the United States, because the northern states actually won the war and slavery was formally abolished. But, it's one thing to have a law that says that slavery is outlawed, and it's another thing to change the actual character of societies, which means all the norms and institutions and values and practices and the economic structure of a society that is fundamentally based on slavery. So it wasn't that easy to kind of just dismantle the institution of slavery. So there was something called the Reconstruction, in which the northern states and the federal government of the United States, which is the central government, it is like the central government we have in India, they assisted the southern states in overcoming their economic dependence on slaves, and of course in reintegrating white and black, or African Americans and white Americans. However, soon after the Reconstruction period, the southern states, again, the ones you can see, if you can read some of the names here, it's Texas, Louisiana, Mississippi, Alabama, Georgia, South Carolina, North Carolina, Virginia, Florida, etc. You can see, and you would have heard of these names because of the fact that global media has, we see so many American shows and see so much American content. I'm sure you've heard of the names of these states. These states passed what are called the Jim Crow laws. So the southern states, or the former Confederate states, passed these Jim Crow laws that upheld racial segregation in all public facilities starting in the 1870s and 1880s. So the Civil War had ended, slavery was formally abolished, right? But society and its values and its legal system and its criminal justice system in the southern states of America refused to accept that verdict entirely and started passing segregation laws that mandated segregation in public facilities. Now, one might wonder, how is this possible, right? Isn't it one country? And some of you may already know the answer to this. You can indicate that in the chat. But the fact is that the United States has a very strong federal system, which means that states have a good amount of autonomy in terms of local laws. And the Jim Crow laws, which mandated segregation of public facilities, racial segregation, they came under local laws. So one very important case in this was Plessy versus Ferguson. This was a case that actually in 1896, even the US Supreme Court upheld the doctrine of separate but equal, which basically legalized Jim Crow and segregation. So this is what Jim Crow actually meant. And it's quite hard to think of this. I mean, we know about apartheid South Africa. We know about other instances historically where, for instance, commoners were not allowed to come near the royalty, or, we know about the caste system in India, but it's actually quite difficult to think about the fact. It's almost unreal to see how long Jim Crow laws continued in a country like the United States, which was already a leading global power by the Second World War. And in fact, even before that, even in the interwar period, the world had sort of started listening to the United States in terms of, and started, coming under the United States global international influence. Even by the 1920s and 30s, but these were decades in which Jim Crow laws and racial segregation was openly practiced in a huge, huge part of the territory of the United States. And this is what it meant. It was an institutionalized economic, educational, and social disadvantage for African Americans. It was enforced in housing, in bank lending practices, in employment preference discrimination, in labor union practices, in public schools, public places, drinking fountains for, separate drinking fountains for whites and blacks, segregated buses, segregated schools, public transport, restaurants. All of this was defined as a public place, and it came under Jim Crow. And, if the state, which is in this case, the local state, but it's also the law, allows this level of segregation, you can imagine what kind of norms and values people would start to strongly defend. In other words, when the law recognizes discrimination, people feel emboldened. So throughout the 1910s, 20s, 30s, African Americans who defied these laws in any way, or sometimes for no reason at all, displeased white Americans in the American South found themselves being subjected to what we would now call extrajudicial killing, which is in America came by the name of lynching. Finally, in 1954, there was a historic case called Brown versus Board of Education, in which public segregation / Jim Crow laws were declared unconstitutional. So in this case, what we see is that the federal legal system prevailed or triumphed over the local laws. And this was required because of the multiple cases of brutality against African Americans, the open civil and legal discrimination that was being practiced, and the amount of hatred and hate crimes that were being sanctioned in the name of Jim Crow. And because very basically, the United States Constitution upholds human dignity and equality, and this was a clear violation of it. So the US Supreme Court struck down Jim Crow with this iconic case, Brown versus Board of Education. However, please remember that law and society cannot, they do not always walk hand in hand. They aren't always in lockstep. So you can have a law that can influence society, or you can have a progressive law which is morally and ethically correct, but society takes a long time to catch up. And these are some of the dilemmas and some of the historical and theoretical examples we discuss a lot in a law school, which also has, a strong social science foundation. So the Jim Crow laws that you can see, they were overturned in 1954. They were further, whatever remained of public segregation was overruled by the Civil Rights Act of 1964 and the Voting Rights Act of 1965. By 1965 and the Voting Rights Act, one could say that civil discrimination, which is discrimination in matters of public affairs between white and Black Americans, came to a complete end. This is when the US Constitution's promise of equality to all citizens was finally, in fact, completed. And you can see how long it took. The US declared its independence from its British colonial master in 1776, and soon after passed its constitution, 1776. And we're talking about nearly 200 years later, right? So this is how society and law can take turns catching up with each other. There was a lot of protest. African Americans were increasingly angry, increasingly disillusioned, increasingly disappointed with the American establishment and with the slow progress of desegregation laws. But there was this historic moment where a young boy, 14-year-old Emmett Till, was lynched. And this was several decades after the last public lynching. The last public lynching, if I'm not mistaken, took place in 1938. But this is in 1964. There was a very tragic incident by which 14-year-old Emmett Till, an African-American schoolboy, had gone to a grocery store to buy apparently some soda after a long day of working in the farm. And he was, in fact, not from the southern states. He was from the north. He was from Chicago, and he was visiting his cousins in Mississippi or Louisiana, one of the southern states. And they went to a store, and there was a woman behind the counter, a white woman, a store owner, who apparently complained that he was inappropriate with her. He behaved inappropriately. And her husband and the husband's brother searched for Emmett Till, found him where he was living with 8 other family members who he was visiting for the summer, kidnapped him, tortured him, killed him, murdered him, and threw his body into the Tallahatchie River. I think that was the name of the river, right? And his body was found several days later. His face was disfigured, his body was bloated, and it caused a massive, massive outcry, because I think at some level African Americans had just had enough. His mother decided not to bury the entire incident, literally and figuratively and metaphorically. And she said that she's going to have an open casket at the funeral, which means that if she wanted everybody to see, in her own words, what they had done to my baby. And, there were huge crowds. This became a galvanizing moment. It became a mobilizing moment for the civil rights struggle. And even though it remained peaceful because of the influence of Martin Luther King, it was obvious that the promise of civil equality and dignity in the American Constitution was not going to be given to African Americans very easily. And there was a lot of rage bubbling under the surface of Martin Luther King Jr.'s call for peaceful protest. Martin Luther King, as you know, was the leader of the African civil rights movement, very heavily influenced by the experience of Mahatma Gandhi in India and the success, as he saw it, of our national liberation struggle. He felt that African Americans should also emulate these nonviolent means. And there he is. And you can see from this quote, right? You can see that King himself is sounding like he's on his last straw. He's saying, I'm not sad that Black Americans are rebelling. This is not only inevitable, but eminently desirable. Black men have slammed the door shut on a past of deadening passivity. He's saying we want to be nonviolent, but you're leaving us with very little choice. There is so much anger. And he further goes on to say that the Black Revolution is much more than a struggle for rights. It is forcing America to face all its interrelated flaws: racism, poverty, militarism, and materialism. So just keep that in mind, these interrelated flaws: racism, poverty, militarism, and materialism, because the point that I'm going to make further on is that you cannot separate the criminal justice system from all of these historical systems of discrimination. And they seep into the system, into the criminal justice system. But let's see a concrete example of how that actually happened many years after King spoke these words. Another somber note to note is that just a few weeks after he made this statement, in a book called A Testament of Hope in 1969, he was himself assassinated. So, was the race problem solved by legal means? It would be nice if it was. It would be reassuring if law by itself could solve the race problem. But not only does the United States show us that law by itself may not be enough if it doesn't work in tandem with other social systems, but in a very ironic twist, law can actually aid further discrimination. How does that happen? Now, what happens by the 1970s in the United States, right? Say Martin Luther King is assassinated at the end of the decade of the 60s. By the 1970s, the United States has developed one of the most extensive records of mass incarceration, which is it has one of the highest numbers of people in jail compared to any other country in the world. So just look at the statistics here. And this didn't happen overnight. This happened over decades. It started in the 1970s, but it happened in the early 2000s. As of December 2023, the US has, this is just a couple of years ago, it has some 1.8 million incarcerated individuals. China is just behind with just 1.7 million, but this is just put these figures in the context of the comparative population sizes of the US and China. China's general population size is more than quadruple that of the US. So by far, the US has the largest proportion of its civilian population in jail compared to any other country in the world. And more than 37% of those incarcerated, jailed for long times. This is not like a lockup for a night, it is jail, and usually after conviction. This includes under trials, are Black. So Blacks only make up 13% of the country's total population, but they form 37%, nearly 40%, more than a third of the total incarcerated population. Now, how did this happen? You might, I mean, it might be tempting to think that, and this is something that is actually quite, unfortunately, quite a common sense assumption that people make, that African Americans just tend to engage in more criminal activity. They have a tendency towards violent crime and so on. But actually, the truth is much more complicated. Um, Beginning in the 1970s, the idea of protecting public safety by implementing policies that were tough on crime became increasingly politically valuable. So, in other words, politicians began to show to their constituencies, successive American presidents, and of course, please remember that the United States has only had one African American president, and we're talking about a period before this. So, successive Americans began to show in their election campaigns that they were going to be tough on crime. Now, that sounds like a good idea, right? Being tough on crime. But in practice, it opened the doors to decades-long discrimination within the criminal justice system. For one, there was staggeringly different sentences for possession and dealing of crack versus ordinary cocaine. And the tough on crime campaign really zeroed in on what they call the war on drugs, which is also a great idea in principle. But actually, what happened in practice is that there were very different forms of sentencing and punishment, right? Remember that law is also about penalties, but very high penalties for the possession of crack cocaine, which is a form of cocaine that was much more common amongst urban, impoverished African Americans. Whereas the white powder cocaine was something that was associated with affluent users who generally tended to be white and tended to be from the most elite sections of American society. So cocaine usage cut across classes and races, but the form that was called crack cocaine, which is sort of a fractioned form of cocaine, was both used, as in consumed, and peddled, that is sold, predominantly by African Americans, almost overwhelmingly by African Americans, because the margins were very small, the price was lower. And the criminal justice system prescribed much harsher punishments for crack cocaine compared to regular cocaine, powder cocaine. Ultimately, in the 1990s, the American Civil Liberties Union found that after the introduction of, and there were these additional laws that were made, which was called mandatory minimums, which is basically that you had to make sure that once somebody was accused of possession of crack cocaine, and this applied only to crack cocaine, they would receive a mandatory minimum sentence, right? No matter what amount they possessed, they had to be in jail for a particular period of time. The American Civil Liberties Union, right, which campaigns for equal civil rights, found that after the introduction of these mandatory minimum sentences for this form of drugs, Black people were facing 49% higher sentences than white people. This led to one writer, Michelle Alexander, coming out with a book called The New Jim Crow. It became a huge talking point, and it was a bestseller. And what she showed meticulously using statistics and using, looking at the criminal justice system in the United States is a really interesting and shocking fact. She argued in the early 2000s that today there are more African Americans under correction control in prison or jail, on probation or parole, than were enslaved in 1850, a decade before the American Civil War began. In major American cities today, more than half of working age African American men are either under correctional control or branded felons and are thus subjected to legalized discrimination for the rest of their lives. Some of you might be aware that once you are a convicted criminal under most criminal justice systems in the world, including India, you lose not just your freedom and your ability to move around and socialize and all of those physical freedoms you lose, but you lose sometimes for life, other civil and political freedoms, right? So not only you're stigmatized, whether you're jailed correctly or wrongly, and fairly or unfairly, once you come out of jail, you continue to be treated like a quote unquote second-class citizen because you're not seen as having the same set of rights as people who have never been convicted. So it's a legal discrimination that continues even after you finish your sentence. So Alexander's argument, this author's argument is that what slavery achieved in the 19th century, mass and unfair and disproportionate incarceration or jailing of African Americans is achieving in the 20th and 21st centuries. So what she's actually saying is that it is discrimination by law, exactly what slavery was and exactly what Jim Crow was, but it doesn't appear as discrimination now because it looks like fair and legal punishment. But if you look at the statistics around the rates at which African American men, especially men, but it can also include women, African American populations are jailed for relatively minor crimes. If you look at the politics behind, those campaigns called the war on terror, the war on crime, the war on drugs, then you can see that this is not something that is this this is a form of legal discrimination that is mirroring rather than reducing social discrimination. It's in fact mirroring and magnifying it. And till date, actually, nobody has really been able to refute any of her statistics or statements. So just coming back to this slide, was the race problem solved by legal means? Not only does it seem that it wasn't solved, but things have become so bad. And I gave mass incarceration as an example, but there has been a lot of work done on other forms of discrimination African Americans face that are also very difficult to openly uh, contest or openly address within the legal system. And some of it I've already mentioned, but there's a practice called redlining, which denies African Americans the same quality of housing that white Americans are allowed. There is also, of course, the very, very persistent problem of racial profiling by the US police force and the law and order agencies when it comes to, their tendency to pull the trigger on suspects. So the whole question of the disproportionate number of African Americans, especially young African American men, killed by trigger happy policemen is what led to the Black Lives Matter protests. You might have heard of Trayvon Martin and many other Black teenagers and young men shot by the police for simply loitering around, for simply looking suspicious, for on suspicion of possessing a firearm without actual evidence. Police officers in trials have testified that, and they have accepted that the chances of them pulling a trigger when they see an African American are much higher than if they see a white American, however suspicious or criminal, quote unquote, he looks. So this is a problem that has not been yet addressed, and Black Lives Matter has attracted a huge following, especially amongst young African Americans, not just African Americans, but also people who support them. So if you see the images, you can see that a lot of young Americans, white and of other communities, have also been supporting these protests. So the race problem continues. Now, just to conclude, this is not, we would require another presentation to talk about India, but India also does conform to a global trend in which the socially and economically marginalized populations have a much higher rate, not only of incarceration, but they have a much higher chance of being awarded a death sentence. We are one of the countries that does have a death penalty. We have capital punishment, we have a death penalty. And again, looking at it statistically, for similar crimes, the likelihood of a person from a social or economic or religious or caste marginalized background being convicted and then being sentenced to the highest possible, harshest punishment and sentence, which is death penalty, the chances, if you're from a social and economically marginalized background, they are more than double. So what we are saying is that if you're not from a marginalized background, if you're educated, if you have a higher caste and class profile, if you're from a dominant religious or social group, your chances of being convicted for a heinous crime, even after that crime has been proved, your chances are actually lower. And of course, statistics do not establish causation. All right. So if some of you are thinking about that, it is not conclusive. However, it is something to think about, especially given the context of what we've just discussed in the case of the United States. There was a case called Bachan Singh versus State of Punjab in 1982, where the Supreme Court of India, in its dissenting opinion by Justice Bhagwati, said he in fact went ahead and said this. This is a Supreme Court judge who gave a dissenting judgment in Bachan Singh, and he said that death sentence has a certain class complexion or class bias, in as much as it is largely the poor and the downtrodden who are the victims of this extreme penalty. This is a caste, class, and educational profile. I can leave it on the screen for you to study. But just to summarize it, level of educational attainment is a very important indicator of whether or not you'll be awarded a death penalty. One, of course, it's an important indicator of whether you would be convicted of a crime, as in the chances of your actually committing a crime go up the lower your educational profile. And that, again, is something that seems to be common sense. But what is far more interesting is that the same level of crime can be committed by an educated and an uneducated person. And within the two of them, the uneducated person is more likely to receive a death penalty. Caste and religious profile. And this would be my final slide. This is the conclusion from a report by an organization which brings out a group of people, actually. It's a civil society group that brings out something called the India Death Penalty Report. And I would just like to conclude by reading out their conclusion, which reiterates many of the points I've been making during the presentation. It is evident that we have too little information about the manner in which the harshest punishment in India's criminal justice system is administered. The political and philosophical debates relevant to the death penalty must be situated in the context of minute details. And here is where I want you to come back to this the second definition of the word discrimination. Discrimination means being able to distinguish between minute details. And what the India Death Penalty Report is concluding is that we need to keep that discrimination when we actually apply something like a death penalty, which is the harshest punishment, and not in the manner that it is happening right now, which is that there might be an implicit bias, it is difficult to prove, but there might be an implicit bias in the minds of judges, which could explain the statistical anomalies. But we have to actually be conscious of our biases and we have to take it into account. So we have to discriminate that we might have biases, and we have to take those biases into account and make sure that those biases don't creep into our judgment. So those debates must be informed by a substantial understanding about the nature of the death penalty. Very often we limit ourselves to thinking about the death penalty purely in terms of an execution, and hardly any attention is paid to the experience of living on death row. An attempt to truly understand that experience should inevitably lead us to a more searching examination of the relevant processes. I will end there. These are some of the conclusions. They should be obvious by now, but you can read them on your own, and the floor is open for questions.
Yeah, we have indeed some questions, but before that, I need to, I was listening to your lecture, and one of those cases, board versus senior education, US. That's one of those cases which was very close to my heart, if you ask. I remember it was taught to us 1 minute. It was taught to us in the law school, and I remember our professor got so emotional that he started crying. And he said, look what situation US was then, that to get a Afro-American kid educated, they had to send the army because there were soldiers with that kid so that he could go and attend the class. That was the spirit of, holding a right of a single individual, which was put to practice. And then Martin Luther King and everything else. Dear students, I hope you got an idea about, why study of social science is so integrated into study of law. And the marriage of these two is something which most of these 5-year courses students do learn. It's very important.
I'd just like to add something to the Brown versus Board of Education, to what you said, that, that it required police to come and enforce desegregation. It also shows that within the federal and the local law enforcement, there can be a fight. The local law enforcement was in favor of segregation because they refused to accept the Supreme Court's ruling.
Yep.
And again, we see that the prejudice can be shared by even law enforcement officers. And the federal law enforcement had to come and suppress not just the white American civilians, but also the local law enforcement. It was almost a state of civil war. America went through many decades of this before they could finally ban segregation.
And become the United States of America. And if you compare it with our country, we are still struggling, but I think Indians have been more receptive to the idea of embracing this change, thanks to our education system and also the mindset of the people who slowly have changed. Though we criticize the country a lot, but I think the laws also have been very protective of people's rights. So we haven't seen a Brown versus board education in India. That does not mean that we are very good, but then again, the drafters of the constitution, like Dr. Bhimrao Ambedkar, to everyone else, they made sure that these things are put on check. Anyway, so we do have some questions where kids are asking questions like Vikas Prajapati. He is attending and he's asking you a question that, ma'am, will there be a time when racism will no longer exist?
It depends on your generation. Okay, but that's a convenient answer. If I were to give a more detailed answer, I would say that I certainly think that it is possible, but it would not come from one pocket of society. It will come because of a sweeping change, both in law and social morality. It needs to be consistently enforced by the government. And what's happening in the United States right now doesn't look very promising, because there is a section of supporters of the Republican Party that, in fact, think of discrimination as legal and racial discrimination against African Americans. In nostalgic terms, they're almost nostalgic for a time when, there were American public spaces looked white. They didn't look mixed. So there are known supporters of white supremacist groups, of the banned Ku Klux Klan, that have been coming out openly in support of President Trump's election. It is not to say that President Trump is also openly supporting them, but he hasn't done enough to distance himself from them. So it's not at this moment looking hopeful for the current scenario, but I think the history of the world shows that racism is, a relatively recent invention. It came out of certain economic and social and moral systems of the 18th century, and I don't think it's going to last for centuries. It is on its way out, but we also need to do our part.
Yeah. Even they have lost so many precedents to this problem, right? As in vaccinations, John Wilkes Booth, the way he laid down everything. Okay, we have a very good question from Sri Radha Sanjay, and she's asking, what threshold of public pressure or dissent forces legal change, even under minority resistant regimes? To what extent does criminal justice system prioritize legitimacy over control, and what shifts that balance?
Could you repeat that? I was trying to read it on the chat. Sorry, but
Okay, it's in the Q&A section, so I'll repeat. It's like, what threshold of public pressure or dissent forces legal change, even under minority resistant regimes? To what extent does the criminal justice system prioritize legitimacy over control, and what shifts that balance?
Yeah, these are good questions, but also it's quite broad. So it would really depend on the context. I think that the criminal justice system has one feature which is both an advantage and a disadvantage. They don't generally think about larger social justice questions. They don't think about patterns in society, which is not to say that judges don't pronounce judgments, especially as you go to the higher courts, not so much in the trial courts, It can happen, but as you go towards the Supreme Court, you will see that there is a lot of judgments will have material that even social scientists and people who are outside of law will find very enlightening, right? Because they'll be commenting on society. But those are exceptions. On the whole, the criminal justice system and the lawyers and the judges are trained to look at details, and they're trained to not look at the larger picture. And that is something that is, like I said, both an advantage and a disadvantage. It's an advantage because it ensures a certain degree of impartiality and neutrality, right? They're not supposed to bring their social prejudices into the courtroom, as we've been talking about. The problem is that if those social patterns are so persistent, as we have been seeing in this presentation, that they in fact do already exist within the criminal justice system in some form or another, maybe in the form of implicit bias, like it's happening with the death penalty or with mass incarceration in the US, or in the case of individual judgments where, a particular judge would have an implicit bias while passing a judgment. That blindness that lady justice is supposed to have, that the criminal justice system prioritizes, right? When you asked about whether it is legitimacy or it is the other thing, I don't remember. Yeah, but yeah, the criminal justice system prioritizes detail. It prioritizes individual cases and case law rather than the big, huge questions that are facing society. And that allows them to actually function in a society that might be quite divided, but come to at least potentially come to a relatively neutral judgment and ruling. But it isn't enough. So again, here, like law and society have to inform each other. I think criminal justice has to be informed by a larger idea of social justice, because law is placed within society.
True. The next question is, what is some good literature to read on the intersection of social values and discrimination, be it books or research papers across nation, but also specific case studies mentioned in this session?
Yes. So Michelle Alexander's book is called The New Jim Crow. There are wonderful books on the American civil rights movement. There are books, there is one book, I don't remember the author's name, but it's on the debate on violence and non-violence within the civil rights movement. I really like the title of it, so I remember it. It's called This Non-Violent Stuff Will Get You Killed. And it actually talks about how Martin Luther King was himself quite ambivalent. I mean, we think of him like we think of Mahatma Gandhi as somebody who was very firmly committed to non-violence. But the book actually starts by describing how a journalist goes to interview him and he sits down on a couch in Martin Luther King's living room, and he gets up immediately because he can sense that he's sitting on a gun. And there are not one but four guns in the house. And King lived in Alabama, which is one of the most racially discriminated, segregated states, and it had a lot of violent crime against the blacks, practiced by Klan members and Klansmen and American white vigilante groups and so on. And it was like, blacks had to protect themselves. They didn't trust the law and order. I'm talking about the 60s here. And ultimately, when King was assassinated, he was assassinated by white supremacists. So his fears turned out to be true. So he was asked by the journalist, you are Dr. King, you are world famous for your non-violence. How is it that you are, there are firearms in your house? And he said, it doesn't hurt to be careful. I have a family to protect. So it just shows that so that book is called This Non-Violent Stuff Will Get You Killed. In the case of India, I think I would strongly suggest that you read the death penalty report. It's available free online, and you can go through some of the statistics. They're really eye-opening. And
Is that the name of a book or a journal?
it's a group of people that it's called the India Death Penalty Report. I'm
Okay.
happy to share it with you, Deepu, if somebody can.
Yeah, we can share post, some readings.
Yeah, I can actually put together a reading list.
Send it across to all the attendees here.
Of
Yeah.
course, yeah.
So any other journal or anything that you would want to share with the kids, you can just share with us.
Actually, Dr. Ambedkar's work on caste, it's called Annihilation of Caste, is a great place to start for India. That's about caste, but given that if you also read the death penalty report, then you'll also see some connections, because the question was about discrimination and social issues, right? So it's a good place to start. And there will be, similarly, there'll be lots of books on, other forms of discrimination. There is excellent work on gender discrimination, for instance, and some of the statistics in the death penalty report actually show that, like in case of men, the number of general category educated men who are convicted of a crime and then awarded the death penalty is very, very tiny. In the case of women, which in general is a very small category, small number of women who actually get the death penalty, because a small number of women are generally committed for crimes. But in the case of women, all of the 11 death row prisoners were from socially marginalized groups, either illiterate, extremely poor. So it is something worth thinking about. Like, if nothing, just from a humane perspective, even if they deserve the death penalty from a legal point of view, you know, and even if we can not prove any discrimination, just looking at some of those stories, and some of the case studies are mentioned in the death penalty report. I mean, some of you who will be going into law, it would be very interesting for you to actually see what's happening, where social marginalization and exclusion and lack of education is leading you down a spiral which is very hard to come out of. I mean, these are people who would get caught in a kind of cycle of crime that they find very hard to come out of. And by chance, if there is an unfair conviction, they cannot afford lawyers because of their backgrounds. So the possibility of them being convicted and then being awarded a harsh punishment is almost unavoidable because of that, kind of downward cycle. Yeah.
So Nani, because since you've read a lot about these things, how successful was these affirmative action in the US?
Yeah, in fact, there's actually just this morning I was reading a nice article. When I say nice, I mean that there was a lot of, again, data and evidence in it, which is always helpful when you're making an argument that may be slightly difficult for people to accept, and it is going against the tide. This article was, in fact, about, there's a lot of work on affirmative action in the US. And I can again put together a small reading list. But the article I was reading today was about whether bureaucrats who are from backgrounds which in India we would call affirmative action reservation, bureaucrats who come from the reservation or reserved category, are any less efficient in the implementation of their duties than those who haven't, who are from the general category. And this was a large-scale study that found that there was absolutely no difference in performance between those from different categories. So that's interesting. And I think in the US as well, they found that what affirmative action has done is that it has made institutions more mixed. And that can have its own beneficial effects. And there's a whole debate on something called intersectionality by Kimberly Crenshaw. Again, I'll leave that for another presentation.
Okay, so Shrishti Lakhotia is asking, good evening to one and all. Firstly, I greatly appreciate your class today. Ma'am, my question to you would be, what measures can be adopted to prevent wrongful convictions, saying how it has huge social and individual implications? Furthermore, what would be apt compensation for those who are wrongly convicted? She's saying her question is vague, but she would love to hear your views.
No, it's not vague at all. It's actually quite clear. What I would like to do is actually ask the other participants to reflect on this. I would like to hear from all of you. This is a big question for us, and it's a big challenge if you want to go into litigation, especially, but any kind of law. It's one of these ongoing, frustrating things that we don't seem to be able to find a perfect solution for. I do have some ideas, but can I hear from the audience about what you think might work?
Uh,
Anybody?
you guys can raise your hand and then we can give you audio rights. Pranali, that is possible, right?
Yes.
Anybody wants to share a suggestion? on wrongful conviction and how that could be.
Anyone can do that. You just need to raise your hand and then we'll give you audio rights. Yeah, we have a hand raised by
Samira.
Samaya. Yeah. Yeah, Samaya. Yeah.
Hi, ma'am. Good evening. According to me, one thing would be to uh, a ensure that all the people, we know that there's a civil that civil liberties gives us the right that everyone can choose have a lawyer of their choosing to defend them. I firstly believe that the state should ensure that you have good lawyers and lawyers provided by the state to defend you. Secondly, judges there should be, if you're mentioning your caste, your class, your annual income, any other discrepancies in your past that could overall affect this outcome, it should be taken into consideration of including the overall context of the case.
Yeah.
And if you are comparing it to a case, like in law, you often compare cases to previous judgments as well, saying that, okay, this judge did this, it's in line with the constitution, so we're going to have the same application. You need to, I think that when you do that, you need to take specific context into account. So if, for example, the judgment you're referencing had a convict that was more affluent than the one you're referencing right now, the judgment needs to be adapted accordingly. I think that's one way to do it.
I would agree. I think those are all sound suggestions. I think the lack of access to good quality legal representation is a crime in itself. I mean, if you're talking about a
We have,
criminal justice,
we have one more hand raised from.
yeah. Please
Yes.
go ahead.
Am I audible?
Yeah, Shrishti.
Yeah. Ma'am, wouldn't, like, it's an open secret that many of times these pleas to look at the conviction again, they're tossed out. It's an open secret that they're tossed out, maybe because of logistical issues, seeing how many of the courts are burdened with so many cases already. But I think giving them, or maybe setting up a different kind of a tribunal or something to hear out these cases is incredibly important. Because if you don't hear these cases, how are you to be able to check if your judgment is correct or not? And like you said, there is, no matter what you do, there will be a little bit of prejudice that comes with every person in the courtroom as well. So I think looking back at your judgments would really help to reduce that kind of prejudice, because you're seeing it from a different person's perspective. I think that would be helpful in reducing the number of wrongful convictions we see.
Absolutely. And the hierarchical system, legal system, the structure,
Yeah.
trial court to the Supreme Court,
Yes,
is
ma'am.
supposed to be exactly that checks and balances system, but we know that it isn't working. So something has to be added to that infrastructure that combines a little bit of, it's a very tricky, it's a very delicate line, and I think you would understand this. You cannot have something like open public pressure on the legal system. On the other hand, the legal system cannot insulate it so completely from public pressure, which is why I have got point 4 here, that like any other profession, ethical, social, and moral scrutiny of legal judgments will ensure that the legal profession and law itself change with the times. And, when it comes to professions like, and, this is something that I would like you all to think about, given that you're considering law as a career, but, doctors and bureaucrats and highly professionalized white collar jobs in our society, very prestigious, with a lot of expertise, they also sometimes suffer from a certain amount of mystification, right? Like people outside don't quite know what's happening inside. And, especially, I mean, you can imagine that if I, as an ordinary citizen who's quite well educated, cannot really decode the law, right? The details of it, then what are the chances that somebody who is illiterate or very, very barely educated, and you can see some of the statistics if I go back to this graph, never went to school, did not complete secondary. If you see some of these people who land up in front of a judge, feeling like everybody around them is speaking in an alien language, right? What are the chances that you could actually represent yourself? So law cannot be so protected in a society that is as unequal as ours. And I mean, if it can happen in the United States, you can imagine what the situation might be here. although we don't have institutionalized racism as they do. That's another problem. That's a massive problem for them that we don't have, but we have other issues, other forms of marginalization. You can actually see it here on the screen. So yeah, I mean, it's you cannot have such secrecy and mystification around the profession. And sometimes judges do like to protect themselves and insulate themselves by using this kind of language that, oh, contempt of court and so on. You would have seen some of these dramatic scenes, courtroom scenes. But law is, at the end of the day, litigation and law and all of these are social services. They're public services, and the public needs to be served. And if that's not happening, we have to think about what to change. So I agree with your suggestion that there should be scrutiny and there should be some form of redressal if the regular system does not work.
We have another hand raised. Devi. Devi wants to speak.
Yeah. Please go ahead.
Yeah, Devi, you can speak now. Are you still there?
Ma'am, am I audible?
Yeah, you are. You are. Please go ahead.
Good evening, ma'am. I suppose the other part of the question was how can these wrongfully convicted people also be compensated by the society and the government? And of course, the obvious ones are the financial compensation, and the emotional compensation would be pretty tricky because if the minimum that the government can offer is some sort of mental wellness therapy, but I thought of how media can play a role in such people's lives, because once they were convicted and they have been a victim of wrongful conviction, their entire social status is like brought down to a very low level, and people will always look at them for their past. And one way this could be somewhat, the effect can be quite less, is through media. If that particular case or that person wishes that the society should also get to know what kind of injustice was done to them, if the court, the government can also bring in the media, if the convicted person, wrongfully convicted person wants to, then the case can somewhat be publicized and they can gain back some amount of reputation that was lost, as well as the unfairness. So not only does it it's not only beneficial for that person, but also to the society in terms of awareness as to how the court is happening. It could inspire students to want to join law and make the law better. And I feel like that would also be a good option for compensation.
Yeah, I mean, I absolutely agree that media is an option. In fact, I was reminded of, have you all heard that recently they completely, like, they laid the Sushant Singh Rajput case to rest and they declared it closed, and they acquitted Riya Chakrabarti, I think that's her name.
Yeah.
Riya Chakrabarti, right?
Yeah,
And
that's it.
they said that there was absolutely no evidence that she was involved in anything, any wrongdoing. And only thing I would add to what you said, Devi, is that it doesn't even need to be the government, because the media is, it's actually in some ways, there's a lot of critique of social media and fake news and so on, but the media is still a public resource. It's a relatively open, public, widely accessed. I would not quite go as far as to say democratic, because of course some groups are more easily able to access media houses. Media houses themselves may decide, this case is newsworthy, this case is not newsworthy. But I do think that with the kind of proliferation we have of media technology, people can even resort to making up content quite cheaply and posting it. And there could be, you could think of, a somewhat charitable enterprise, a channel that actually hosts these wrongfully convicted people who can tell their own stories. It could be on mainstream media, it could be on social media. Newspapers could think of starting a column. I agree with you that there are lots of possibilities, but also that it's a lot of stigma. And sometimes it even doesn't go away, even after you've cleared your name. So, I mean, I think the first step would be, again, to prevent the wrongful conviction. And then if things become, they go in the wrong direction, then to have, a really public platform for telling your story and to stand tall and stand with respect in front of society and your peers and say, please clear my name. People used to have procedures for doing this in medieval times. People used to come in front of panchayats and they used to say, you didn't find evidence, clear my name. Take the blemish away from my name. And I think that's something that we still need to do, because society and social pressure and peer pressure they continue to be very important for people, and the legal system should take cognizance of that, and we should actually make space for that. We should give that platform to people. By the way, somewhat less, somewhat again slightly serious, on a serious note, Emmett Till's murderers, after the trial was over, they were protected by something called double jeopardy, whereby you cannot incriminate yourself. And they openly accepted that they had in fact committed the crime after they were acquitted. So law has to be, the law is an instrument and it has to be used for good. In this case, it wasn't.
Okay, there is another question by Rohan Vedya. He's saying, good evening, ma'am. You made an interesting point about progressive legal systems actually reinforcing historical biases. I find myself agreeing with it in a way, but I'm not very informed on the topic, but it would be great if you could further elaborate on it a bit.
Historical biases being perpetuated by the legal system?
Yeah, progressive legal systems reinforcing historical bias.
Yeah, I mean, I don't know what you mean by the progressive legal system. The American legal system is similar to any other in the world. We have a lot of commonality in legal systems, at least in English-speaking countries in the world. And the laws by themselves are actually very often quite progressive. Although, like, again, we discussed in the case of the United States, which is different from India, where the laws are progressive, but they get misinterpreted, or the bias does not get left out of it. In the case of pre-1965 United States, even the laws were discriminatory. So that, I mean, in that sense, it wasn't a progressive legal system for all citizens and for all constituencies and all groups of people. Even the women were not able to assert their right to equal pay until 1972, the Equal Rights Amendment. And even then, after that, it's been very difficult for women to actually prove employment discrimination, because it can be quite subtle. So we have used concepts like glass ceiling and all that. So there are two problems. One is that the laws themselves can be stuck in a previous era of history, and they will express the historical patterns from that time, and there's a kind of sticky quality to law. It kind of gets stuck, because law is in a way a concrete form of social morality. Like it's a version of social morality, but it has more weight than social morality in the modern world, because we are all supposed to be following one single system of law, and so it's supposed to be very authoritative, but it can get stuck because of its very authority, and it can be quite difficult to move it forward. So that can happen. That's how that even seemingly progressive legal systems can have remnants of the past, or sometimes they can even come up with new discriminatory practices. And this is rarer. It's not so common, thankfully. But if I understood your question correctly, that's what happens with these historical systems remaining within progressive systems of law. Having said that, India has it has a remarkably progressive constitution. I think we did a very good job in terms of, because we were also a society that was dealing with various forms of historical discrimination, some of which actually got stronger during the colonial period. And this is something that we discuss in some of our courses. It's not something we think about in such detail in school, but in college, you'll have a chance to really, really think more, study all of these systems more deeply. So we had a challenge, in the 1940s, that we wanted to overnight create a society that was at par with some of the most progressive social and legal systems of the world. And while we had been changing as well under colonial rule, some things had actually got frozen. because the colonial state didn't want to look at them. The British state had no interest in looking at them. The amount of effort it took for them to ban sati in 1829, the governor just kept sitting on that legislation. It was because of the efforts of social reformers and all that finally it happened. And once they did it, they got a lot of backlash from generally upper caste, like priests and so on, people who were in favor of the practice. And the colonial state then withdrew. For nearly 50 years, it refused to touch any social reform because it said we don't want to be unpopular. So if we had been under an indigenous government, it's possible, some people have argued, that we might have continued, our laws may have continued to evolve quite naturally, but under the colonial state, some things just got stuck. Things they were not interested in changing because they thought, oh, they don't want to inflame passions. So we had a huge challenge in the 1940s. We had to suddenly take this very, very diverse society and bring it kind of overnight into the modern world. And I think our constitution makers, given the challenges, did a very, very decent job. But as I'm saying in this presentation, and as I do say in my classes and in general, it's only one part of the story. We have to have progressive social movements, progressive politics, progressive cultural practices. We have to have a progressive educational institution, progressive workplace, everything. All those values have to come out of the constitution and go everywhere. And people have to embrace those values. And then we can actually start having a debate on what we want to change and what we want to keep, and where are these implicit biases coming in, and what is going on, and why are these judgments like this, etc., etc. But we have a good foundation. We have a very good foundation.
So that's a very interesting question. I think most students also would be interested to know the answer. It's by anonymous attendee, but it says, what exactly started the racial discrimination? Is it just the superior nature of the whites?
I would like to know from anonymous attendee, what about the whites do you find superior?
So he is also wondering that what on the world started this discrimination? How did
Well,
this?
it was, yeah, it's actually quite an obvious answer if you think about it. Do you want to take a guess? What started the racial discrimination? Race as an idea is a kind of a pseudo-biological idea. It actually doesn't have any biological basis. Again, would require a separate presentation to talk about it. But there is no genetic basis to race. Race is in fact visual difference, right? It's skin color difference, it's different features, maybe different hair texture, and there are some broad differences in the global population. But in the 19th century, the Europeans, they came up with this theory that there were only 5 great races in the world, and they arranged them hierarchically. And they didn't bother giving any medical, genetic, biological justification for it. It was a kind of pseudo-scientific theory. They came up with it because in real life, these different populations in the world were geographically in different areas of the world. And can you guess what was happening before this theory was invented? How were those different geographical areas in the world interacting with each other? What is going on in the 19th century? Anybody wants to answer this?
Anyone?
Did we have flights and international travel and so on? Who were the people traveling? For what purpose were they traveling? Why was there contact between different parts?
We have an answer: trade, colonialism.
Correct, exactly. So racism is a theory that is riding piggyback on a pre-existing economic and social system, which is trade and colonialism.
Very good.
Now, who was doing trade and colonialism? It was the white Europeans. They needed to have a kind of a system in which they needed to justify that the rest of the world was not as good as them. And so in a way, colonialism is justified. So what they did is that they took all these 4 populations that were not white of the world, put them under, that's a huge number of people. They put them under these just 4 categories, put them in themselves in the 5th category, and they said, ye char, these are less. And then they invented all kinds of theories around it. So I would really be curious to know, what is the supremacy as such? It's possible, yes, that, in a world that is dominated by white culture, we find it very hard to think of non-white populations as intrinsically good, intrinsically beautiful, intrinsically moral, etc., etc. But this is 200 years of colonialism that has really trained us to think like this. And in a way, it's still continuing because global media, etc., is representing the interests of those countries much better than ours. So we're a bit lost when it comes to our own culture, our own self-esteem, and so on. It's difficult to, because in a way racism is still going on, right? But it's a theory. They invented a theory. It's not fact.
So it's basically an economic theory, just to restrict things within few hands. Some division had to be there, so yeah, why not?
It's a pseudo-biological theory, pseudo-scientific theory, which is used to justify an economic system. Yes.
Simple. Economics is actually the base of everything.
Yeah.
Everything.
And in
That's
the United States, the economics was very profitable for the whites, no? Slaves actually built the great wealth of America for a century and a half before they started pushing back and saying that you cannot not pay us for our labor and you cannot own our bodies and our souls.
I think one of the best businesses they built was banks. You know, the
Oh,
most profitable.
slavery has been one of the most profitable businesses in history.
So last question of the day, Sunalini, I know we have spent a lot of time and we are way beyond our prescribed time, but this question seems very interesting where Sri Radha Sunday is asking slightly tangential, but do you think AI will be able to reform the way law interacts with people from more vulnerable backgrounds, like the prediction of AI lawyers, albeit the issues? Do you think it will create more good than harm?
AI is a very, very mixed bag. I think potentially all technology should be democratized in terms of access, because, otherwise it will end up reinforcing the control of certain small exclusive groups of people on everything. So, and technology can be expensive, it can be difficult to access, just like the legal system is, not accessible to everybody. Technology also can be one of those things that's difficult to access. But I do think that AI has the potential to be very widely accessed. The problem is that in recent times, we've seen a lot of like ghost judgments and like phantom judgments and what AI scientists call hallucinations, right? Large language models, which is what AI is based on, is prone, unfortunately, to hallucinating data. And so we haven't really solved the problem of that. And it can get very problematic, you can imagine, in the case of legal judgments, because people's lives depend on it. And we have too many instances now of either lawyers using fake cases, which they might be unaware of, to make arguments, or judges relying on fake case law, phantom case law, which doesn't exist. So if it is, again, it requires regulation. AI is one of those things that should not get ahead of law. It should be regulated by law. And if it is regulated, and if that regulation gives poor people access or marginalized groups access, then there is potential for sure. It can cut costs. But right now I'm skeptical.
Okay, I think we've come to the end of the session. There are more questions, but I would appreciate these in some classroom sometime. And we have the basic reason is we have jumped the time. And thanks to this exceptional discussion and discourse by Sunalini, I think you guys have started thinking on these lines. The readings which have been discussed in this class will be sent to you via mail by us with the recording of the session also, so that in your free time you could just go through the lessons and also read those things which we have discussed here. Okay, so thank you so much, Sunalini, for sparing your time. I understand it was exam time and the kids were also busy, and you also spared your time and you managed to take out time. But I think these are the sessions that
I really appreciated this interaction. Actually, the questions were very interesting, and we hope to see some of you in classes.
You are going to see majority of them in the classes. Most of these are the students who have been offered and enrolled also. So that's also interaction between you and them, so that you also get an idea about the kind of students that are getting into our law school. Okay, thank you so much to the attendees and also to the parents. I could guess some parents were also attending and they were also asking a few questions.
Oh, nice. Okay.
Yeah.
Yeah.
Thank you so much to each one of you, and happy weekend, and happy Gudi
Thank
Padwa.
you to you, Deepu, for organizing this, and to Mrinalini
Yeah.
and the admissions team. And yeah, everybody have a great weekend. Thank you.
Yeah. Happy weekend and happy Gudi Padwa to all the ones who are in Maharashtra. Take care. Bye-bye.